Erect upright, kanila sa ilos hangin.
AG, good morning. The Chief Justice ruled this morning in the constitutional challenge brought by the Mohammeds. Could you explain that ruling? I think it was two-part, more or less.
So thank you very much, and you're correct. The Chief Justice today handed down a 26-page ruling in the constitutional challenge filed by the Mohammeds. In that challenge, they argued that a number of sections of the Fugitive Offenders Act were unconstitutional. The Chief Justice essentially dismissed the claim and ruled that almost all the sections that they challenged were consistent with the Constitution and therefore did not violate the Constitution. The Chief Justice ruled that one minor subsection of the Act was unconstitutional. Significantly, that minor subsection has no impact whatsoever on the extradition process. That section allowed for, well, rather mandated a court in Guyana to imply if there is the absence of this provision against extradition to a third country, that if that is absent, a court must imply that it is there. That is unnecessary because our previous rulings in Sobers and in King said that there is a protection against extradition to a third country. The point being that that section has no relevance whatsoever, either to these proceedings or to any extradition proceedings. And we knew that from the beginning. We basically said that in our submissions, that the section has no bearing, it has no, it is not germane, and it doesn't affect in any form or fashion any extradition proceedings in Guyana. So it being declared as unconstitutional is of no moment. The fact is strengthened by an undertaking that the US has given already, that should the Mohammeds be extradited, they will not be extradited to a third state. So you have that there, an undertaking from the US that came contemporaneous with the request for extradition, and we asked for that in anticipation of a possible ruling like this. But in any event, we have the treaty itself that prohibits an extradition to a third country unless the minister in Guyana gives the authorization for that to be done. So, by and large, the ruling has cleared the way again for the extradition process to continue. Now, what I want to make very clear is that this challenge, as well as the challenge that was heard and determined before by the Chief Justice, were filed long after the proceedings began in the magistrate's court. And here it is, even though you had adjournments, you have these proceedings being concluded with reasonable dispatch, though they began long after the proceedings started in the magistrate's court. You have been in these proceedings from the inception. You saw the dozens of pages of pleadings that were filed. You saw submissions that were made. You saw how many lawyers were permitted to argue. And yet, all these proceedings are concluded. And that one in the magistrate court continues to languish. What is even More telling is the fact that the Chief Justice's previous ruling was appealed by the Mohammeds, and the appellate court has already given directions on how we are to proceed, and a date has already been fixed for the presentation of arguments. And yet, the magistrate court continues to be the subject of deliberate strategies to delay, both from the lawyers as well as from the subjects. You're hearing fabricated medical explanations proffered. You're hearing explanations that one person was admitted to the hospital, when in fact, when the hospital records were checked, the person was never admitted. Photographs are taken with persons on a bed. Then you have another hair raising tale about tires being slashed, about cars being broken into. All these are deliberate, concocted stories to dilate and delay the matter. And unfortunately, they seem to be yielding success in the magistrate's court, both by the clients as well as by the lawyers. You have cross examination taking place that, in my respectful view, are wholly irrelevant. In extradition proceedings, the bundle that is the subject of the proceedings emanate from the requesting state. No permanent secretary in Guyana has knowledge or ought to have knowledge of that bundle. It was not prepared in Guyana. It consists of the charge, the indictment, and the evidence, all of which took place in the United States. And here it is, you have a deliberate attempt being employed to ask with the witness one set of questions that the witness cannot answer. And that is going on ad nauseum. Compare it with the Bino extradition, and you see the comparative difference. And the Bino extradition exemplifies how extraditions are done. And I'm happy that it occurred while this one was going on. The same process, absolutely the same process was employed. The same signet persons in America send the documents. They were signed by the very officials. They were received by the Ministry of Foreign Affairs. They were transmitted to the Ministry of Home Affairs. And it followed that course. And everything occurred with seamless ease. The gentleman was arrested. He came and he was remanded on what is comparatively a far less serious offense than the offenses for which the Mohammeds are charged. This guy is charged with some minor credit card offense. These others are charged with international financial crime, money laundering, and they were granted bail, and this person was remanded, and I am told that he has already signaled an intent to surrender, meaning that he's going to go to the US to face his trials. His trial. The point I am making is that the entire process is going to be concluded in a matter of days. And here it is, you have a deliberate attempt being made not only to delay, but to cast aspersions on the process, alleging that there is political victimization, there is political vendetta, and that there is some international conspiracy against the Mohammed. When the legal process unfolds this way, and this is how extraditions are done. But these people feel that they are special, and therefore they must not be subject to any extradition process, though they are indicted for 18 serious criminal offenses in a state or by a court in southern Florida. And
AG,
what I believe is worse, just before let me conclude
no
this
problem.
point, is that the magistrates court, unfortunately, seem to be lending its imprimatur to this shenaniganism, for want of a better word, that is being unfolding in the magistrates court.
AG, I just wanted to ask pointedly, based on how the decision was handed down this morning, do you think it delivers a clear win for any one side? And do you foresee an appeal coming?
It is not about winning or losing. It's about the rule of law and the extradition process. What the judge has essentially done is clear the way once again for the extradition process to continue. That is what they wanted to prohibit. They were saying that the entire scheme, the entire legislative scheme under which the extradition is being done, is unconstitutional. And the judge said, no, no, no. One minor part of it is unconstitutional. And that is neither here nor there because it doesn't change anything. And that is what is important. And that's what I explained from the beginning. Yes.
AG, with regards to the case in the magistrate's court, do you believe that it should have been done by way of paper committal as against a PI? Could you elaborate on that?
Look, the section 50 of the Fugitive Offenders Act provides that in the conduct of the extradition process in the magistrate's court, the magistrate must exercise all powers as nearly as possible as a magistrate exercising powers in a committal hearing. That's the exact language. Now, when you go to what a committal hearing now is in Guyana, we have abolished oral committal hearings. And committal hearings are done by paper committal. So the papers are what should have been used. But let us say that the magistrate is flexing. That doesn't mean that you're going to embark or permit cross examination that are wholly irrelevant because I can't ask you things that you don't know and you cannot know and you ought not to know under the pretext of cross examination. You can only know you've only received a bundle from the United States and you have processed it in your ministry and transmitted it to the next relevant official. That is what it appears as not just not nothing more. So you ought not to. The law prohibits examination, cross examination outside of those parameters. Here they're asking all manner of questions. And lawyers have a duty. They are officers of the court. And they have a duty to respect the process of the court. Unfortunately, what is going on there, and I say this with the greatest of respect, is bringing the administration of justice into disrepute because you have the ordinary man in the street watching on and they are seeing these things. They don't understand it necessarily, but they know, they have common sense and they know that these questions ought not to be asked, cannot be answered. And then you have the Bino case that comes on the heel and presents a radically different picture of what the extradition process looks like. And the Bino case reflects 99.9% of our extraditions are done not only in Guyana, but worldwide. You didn't hear any big fanfare and allegations of persecution and abuse of process. The man was arrested just like how the Mohammed was arrested. He was brought to the court, he was remanded on a minor charge, in my view, when compared to what the Mohammeds have been charged with, and not an utterance of vindictiveness, vendetta, and now I'm told that the man is going to surrender and go and face his accusers. That is what extradition requires, and that is how it has always been done. 99.9% of extraditions are done that way, and that's why a lot of people don't hear about extradition because it is quietly done. You know how many extraditions we have done over the years, and it doesn't attract all this public attention and all this grand fiasco that's taking place and this victimhood. that is being portrayed and this political persecution that is being played out. And all of this is simply to defeat the legal process. And unfortunately, it seems to be gaining ground.
Thank you so much.
Thank you, sir.
Uh-huh.